Hello students and welcome to the lecture. So students, basically in this lecture, as we know that we have started the preamble of the constitution and these are the topics we have scheduled for the discussion, like introduction of the constitution, text of the preamble, ingredients of the preamble, alright, keywords in the preamble as part of the constitution, things we should note about the preamble and the amendability of the preamble. Alright, and basically out of this we had finished the introduction part, text of the preamble, ingredients of the preamble. These were the three topics we had finished in the previous lecture, and what we were started for discussion, that we had started the discussion for the keywords in the preamble. So we will continue from where we had left. All right. So about this I had told you. All right. Now come forward. So in 1949, India declared the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth. This extra constitutional declaration does not affect India's sovereignty in any manner. So basically what happened, that however in a preamble we said that we are the sovereign nation. It means that we are fully independent. Okay, but still in 1949 India basically continued its journey as a member of Commonwealth of Nations. Now what are the Commonwealth of Nations? So basically you could say that the Commonwealth of Nations is basically used for declare the all the British colonies. Okay, like whatsoever countries was under the British colonies, these were the Commonwealth of Nations. All right, so India was one amongst them. All right, so in 1949 India continued its membership as a Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth. All right, but this extra constitutional declaration, because it was not mentioned in the constitution at anywhere, India's sovereignty in any manner is not getting affected. All right, further, India's membership of the UNO, United Nations Organization, also in no way constitute a limitation on her sovereignty. It means that however we are the part of these international organizations, but we are independent on our own. Okay, these organizations could not participate in our internal politics and our external matters. All right, being a sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state. Got it? Thereafter, the word socialist, even before the term was added by the 42nd Amendment Act in 1976, the constitution had a socialist content in the form of certain directive principle of state policy. Okay, so you could say it is not like that when we adopted the word in 42nd Amendment Act of 1976. Then only we became a socialist. No, not like this. Basically, prior to this also, by the power of directive principle of state policy, we had the socialist nature. All right, so that is the thing. Okay, in other words, what was hitherto implicit in the constitution has now been made explicit. Okay, so basically what happened, through this act only we, you could say, officially published it. All right, like we are the socialist country. All right, however we had the feature already with us, but then we added this word in the preamble to make it explicit form. In other words, okay, I had told you, moreover, the Congress party itself adopted a resolution to establish a socialistic pattern of society in its Avdi session as early as in 1955 and took measures accordingly. Okay, notably, the Indian brand of socialism is a democratic socialism and not a communistic socialism, also known as state socialism. It means that basically in India, democratic socialism means that through government policies and welfare approach, we should do a socialist behavior with the people, not like a communist. It means that all the resources will be held by the government, then the government will decide what to produce, how to produce, for whom to produce. These are the three basic questions and all. All right. And this involves the nationalization of all means of production and distribution and abolition of private property. All right. Like all of the means of production will be held by the state. The state will distribute among the people and no private property would be there. But in India, we know that these kind of practices are not there. Democratic socialism, on the other hand, holds faith in the mixed economy, where both the public, you can say the government sectors, and the private sector coexist side by side. It means that instead of giving the entire economy to one sector only, in mixed economy, we include both the sectors as side by side. As the Supreme Court says, democratic socialism aims to end poverty, ignorance, disease, and equality of opportunity. All right. Indian socialism is a blend of Marxism and the Gandhism, leaning heavily towards the Gandhian socialism. Okay. So remember, Marxism is basically highly inclined towards the communism. All right. The new economic policy of 1991, in which we had introduced the words like the liberalization, privatization, and the globalization. Okay. However, diluted the socialist credential of the Indian state. All right. Because in which the government had reduced its control and basically increased the private partnership. Thereafter, the another word was secular. The term secular was too added by the 42nd Constitutional Amendment Act of 1976. However, the Supreme Court said in 1974, although the words secular state were not expressly mentioned in the Constitution, okay, there can be no doubt that the constitution makers wanted to establish such a state. Accordingly, Articles 25 to 28 guaranteeing the fundamental rights to freedom of religion have been included in the Constitution. All right, it means that basically when we were making the Constitution, however, we had added the Articles 25 to 28, which provides the religious freedom. All right, but the word secular was added through the 42nd Constitutional Amendment Act of 1976. Got it? The Indian Constitution embodies the positive concept of secularism. Therefore, all religions in our country, irrespective of their strength, have the same status and support from the state. It means that basically doesn't matter that whether the religion is in majority or in minority. All right, the people of that particular faith or religions will be protected and will be provided the equal status from the state or the government. All right, so that's why it is known as the positive concept of the secularism. Okay, and as we had discussed that in Western countries, basically there is a negative secularism, right? Why? Because we had discussed that in that particular states, the state has nothing to do with the religion. Okay, whatever the religion is doing, the government will not interfere. But in India, it is not like that. The government will not give privilege to any particular religion, but the government could participate or could interfere in the religious activities if necessary. Okay. Thereafter, the democratic sense. Our democratic polity is stipulated in the preamble based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. It means that when we talk about India, its resources, its political, economical, and social aspects, all of these things will be governed by the government of the country. All right. So the government will have the power to do all the things, but to make the government responsible, basically what we had done, that we had given the supreme power to the people. Like whatsoever the government will be, the people would be the one who will decide the government by voting. All right. So government is become responsible towards the people of India. Democracy is two types, like direct and indirect. In direct democracy, the people exercise their supreme power directly, as in the case of Switzerland. There are four devices of the direct democracy, namely the referendum, initiative, recall, and plebiscite. All right. It means that through these measures, through referendum, through initiative, through recall, and through plebiscite, basically the people will participate into the decision making of the government. All right. Whereas in indirect democracy, on the other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and makes the law. Okay. So basically, you could say people like me and you could not allow to directly participate into the decision making process. All right. We generally elect the representative, and then the representative will be the part of the government and will participate in lawmaking procedure for our welfare. All right. So that's why it is known as the indirect democracy. This type of democracy, also known as representative democracy, all right, and this is also of the two types, like the parliamentary and the presidential. All right. So what do you mean by this? Let's see. The Indian Constitution provides for the representative parliamentary democracy, under which the executive is responsible to the legislature for all its policies and action. Okay. So remember, India is having the indirect democracy. Like me and you, the general people are not allowed to participate into the state matters directly. But however, through our representatives, we could direct the policies in our favor. Okay. And remember, we had the parliamentary democracy, so that the executive is responsible for the legislature for policies and action. Okay. We have the concept of universal adult franchise, periodic elections, rule of law, independence of judiciary, and absence of discrimination on certain grounds are the manifestation of the democratic character of the Indian polity. All right. The term democracy is used in the preamble in the broader sense, embracing not only political democracy but also social and economic democracy. All right. So basically, all the other factors are provides the political democracy. All right. So Indian Constitution is does not only incline on the political democracy but also for the social and the economic democracy. So remember this point also. This dimension was stressed by Dr. Ambedkar in his concluding speech in the Constituent Assembly on November 25, 1949 in the following way. Political democracy cannot last unless there is lies at the base of its social democracy. Okay? What does social democracy mean? Means a way of life which recognizes liberty, equality, and fraternity. Principles of liberty, equality, and fraternity are not to be treated as separate items in the Trinity. They form a union of Trinity in the sense that to diverge one form from the other is to defeat the very purpose of the democracy. Liberty cannot be diverse from equality, equality cannot be diverse from liberty, nor can liability and equality be diverse from fraternity. So basically, what he said the political democracy could not sustain if the social democracy is not in the base. And social democracy basically means that we should recognize the principle of liberty, equality, and fraternity. But we also keep this thing in our mind that these principles are not separated from each other. All right, these principles are indulged into each other. Like liberty is connected with the equality, equality connected with the liberty. All right, it's not like that. They both are different and you can say separate thing. All right. What are the keywords in the preamble? Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill individual initiative. All right. In the same contents, the Supreme Court observed in the 1997 that the Constitution envisions to establish an egalitarian social order rendering to every citizen social, economic, and political justice in a social and economic democracy of a Bharat Republic. Okay, so same thing which were stressed by the B.R. Ambedkar. The same thing was observed by the Supreme Court in 1979. Sorry, 1997. All right. Thereafter, the next word what we have the republic. The democratic polity can be classified into two categories: monarchy and the republic. In a monarchy, the head of the state, usually is the king or queen, enjoys the hereditary position. He comes into office through succession. Example is Britain. There is no election, no voting for the monarch system. In republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period, like US. Alright. Therefore, the term republic in our preamble indicates that India has an elected head called the president, which I had told you in the starting. Alright. Elected indirectly for a fixed period of 5 years. Why? Because when we talk about the direct election and when we talk about the indirect elections, so what is the difference? In direct elections, general people could participate. In indirect elections, only a particular electoral could participate. Alright. Thereafter, the word justice. The term justice in the preamble embraces three distinct forms like the social, economical, and political, secured through various provisions of the fundamental rights and directive principles. Social justice denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex, and so on. Alright? It means absence of privileges being extended to any particular section of the society and improvement in the conditions of backward classes like ST, SCs, OBCs, and women. Alright? Economic justice denotes the non-discrimination between people on the basis of economic factors, involves the elimination of glaring inequalities in wealth, income, and property. The combination of social justice and economic justice denotes what is known as the distributive justice. Alright? Political justice implies that all citizens should have the equal political rights, equal access to all political offices, and equal voice in the government, as we had discussed. Ideal of justice, social, economic, and political has been taken from the Russian Revolution 1970. So remember this thing. Alright? Like the liberty is very easy. I had already told you. Now just read the formal definition. Liberty means the absence of restraint on the activities of individuals and at the same time providing opportunities for the development of individual personalities. The preamble secures to all citizens of India liberty of thought, expression, belief, faith, and worship. Whatever they want to do, they could through fair fundamental rights enforceable in law, in court of law in case of violation. Okay, so basically this liberty is powered by fundamental rights mentioned in Article 25 to Articles 28. Liberty is elaborated in the preamble is very essential for the successful functioning of the Indian democratic state. Why? Because we said that India is a free country and the people of India is free in their respective areas. Alright. So if the liberty is not there, then what do you mean by the free? However, liberty does not mean license to do what one likes and has to be enjoyed within the limitations mentioned in the constitution itself. It means that you could say, basically, we have provided the liberty through our constitution, but also we had provided some limitations on this. Alright. And what do you mean by this? We will see in the lecture of fundamental rights. In brief, the liberty conceived by the preamble of the fundamental right is not absolute but qualified. I will explain you this thing in the fundamental rights section in the proper sense. Ideals of liberty, equality, and fraternity in a preamble have been taken from the French Revolution 1789 to 1799. Alright, equality. Term equality means the absence of special privileges to any section of society. Provisions of adequate opportunities for all individuals without any discrimination. Preamble secures to all citizens of India equality of status and opportunity. Provision embraces three dimensions of equality like the civic, political, and the economic. The following provisions of the chapter on fundamental rights ensure the civic equality, like equality before the law, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, equality of opportunity in matters of public employment, abolition of untouchability, abolition of titles. There are two provisions in the Constitution that seek to achieve political equality. One, no person is to be declared ineligible for inclusion in electoral rolls on grounds of religion, race, caste, or sex. Article 325. 2. Elections to the Lok Sabha and state assemblies to be based on the adult suffrage. Article 326. The directive principle of state policy. Article 39 secures to men and women equal rights to an adequate means of livelihood and equal pay for equal work. Okay. Fraternity. Fraternity means a sense of brotherhood. The Constitution promotes this feeling of fraternity by the system of single citizenship. Also, the fundamental duties, Article 51A, says that it shall be the duty of every citizen of the India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, or the sectional diversity. The preamble declares that the fraternity has to ensure the two things. The first is the dignity of the individual, and second is the unity and integrity of the nation. Alright, the word integrity has been added to the preamble by the 42nd Constitutional Amendment Act 1976. Okay, thereafter, according to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the phrase dignity of the individual signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but that it also recognizes that the personality of every individual is sacred, highlighted through some of the provisions of the fundamental rights and the directive principle of the state policy, ensures the dignity of the individuals. Okay, so remember both the fundamental rights and the directive principles of state policy, they both work together to ensure the dignity of individuals. Further, the fundamental duties, Article 51A, also protect the dignity of women by stating that it shall be the duty of every citizen of India to renounce practices derogatory to the dignity of women, and makes it the duty of every citizen of India to uphold and protect the sovereignty, unity, and integrity of the country. Alright? The phrase unity and integrity of the nation embraces both the psychological and territorial dimensions of the nation and the integration. Alright? Article 1 of the Constitution describes India as a union of states to make it clear that the states have no right to secede from the union, implying the indissoluble nature of the Indian Union. Okay? And remember that Indian Union is not a part of any agreement. Alright? So, no state of the country is having the right to get separated from the country. Aims at overcoming inherence to the national integration like the communalism, regionalism, casteism, linguism, and secessionism, and so on. Got it? One of the controversies about the preamble is to whether it's a part of the Constitution or not. In the Berubari Union case 1960, Supreme Court said that the preamble shows the general purposes behind the several provisions in the Constitution, thus a key to the minds of the makers of the Constitution. Okay? Further, where the terms used in any article are ambiguous or capable of more than one meaning, some assistance and interpretation may be taken from the objectives enshrined in the preamble. Got it? Despite this recognition of the significance of the preamble, Supreme Court specifically opined that the preamble is not the part of the Constitution. Why? because the constitution was adopted on 24th November 1949 and preamble was adopted on 26th November 1949 as a preface or summary. So it does not having the specific means of the constitution. All right, or you could say it's only working as a you can say the summary part. In Keshav Bharti case 1973, the Supreme Court rejected the earlier opinion and held that preamble is the part of the constitution. Later, the Supreme Court admitted that preamble is the part of the constitution. Okay. Observe that the preamble is of extreme and the constitution should be read and interpreted in the light of grand and noble vision expressed in the preamble. LIC of India case 1995, Supreme Court again held that the preamble is an integral part of the constitution because it contains the summary and preface which are the part of the constitution. Like any other part of the constitution, preamble was also enacted by the Constituent Assembly, but after the rest of the constitution was already enacted. The reason for inserting the preamble at the end was to ensure that it was in conformity with the constitution as adopted by the Constituent Assembly. While forwarding the preamble for votes, the President of India, or you can say the President of Constituent Assembly of that time, said the caution is that preamble stands the part of the constitution. All right. The motion was then adopted. Hence, the current opinion held by the Supreme Court that the preamble is a part of the constitution is in consonance with the opinion of the founding fathers of the constitution. Okay, but two things which we are required to note about the constitution is that the preamble is neither a source of power to the legislature nor a prohibition upon the powers of the legislature. Non-justicable, that is, provisions are not enforceable in the court. Why? Because these are not the provisions of the constitution, but just the preface or summary of the constitution. All right. What is the amenability of the preamble? The question as to whether the preamble can be amended under Article 368 of the Constitution arose for the first time in the historical Keshav Nanda Bharti case 1973. Was urged that the preamble cannot be amended as it is not a part of the Constitution. The petitioner contended that the amending power in Article 368 cannot be used to destroy or damage the basic elements of the fundamental features of the Constitution, which are enshrined in the preamble. The Supreme Court, however, held that the preamble is a part of the Constitution. All right. The court stated that the opinion tendered by in the Birubari case 1960 in this regard was wrong and held that the preamble can be amended subject to the condition that no amendment is done to the basic features. It means that the preamble could be amended but basic features could not be. In other words, the court held that the basic elements or the fundamental features of the Constitution as contained in the preamble cannot be altered by amendment under Article 368. Preamble has been amended only once so far in 1976, as we know that the words like the socialist, secular and integrated were added. Alright. So students, basically in this lecture we had finished the preamble part. In the next lecture we will start with some other topic. Till then just revise all the facts and figures which we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and what we say thank you.